Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to the Aitken Robertson YouTube channel. I'm Melanie van Orde, your paralegal host, along with Counsel Dan Lemaire. Today's topic is Section 276 applications in sexual assault cases. We'll discuss the criminal code specific provisions that limits the admissibility of a complainant's sexual history, commonly known as the rape shield. Join us today as these applications work and their significance in sexual assault cases. Hi, Dan.
Hi, Melanie.
How are you doing?
I'm doing well. How are you?
I'm doing well, thank you. What are Section 276 applications?
So in a sexual assault trial, if you are facing that sort of charge, your lawyer cannot cross-examine the complainant about any other sexual activity besides that has to do with the actual allegation, unless you bring what is called the Section 276 application. Essentially, you need to ask the court in advance for permission to do that, and you need to articulate a reason why you need to do that that does not depend on what are called the twin myths.
Dan, would you mind explaining to us what is considered the twin myths?
So the twin myths are what the Supreme Court of Canada has recognized as two inferences that cannot ever be drawn from a complainant's prior sexual activity. And they are, number one, that the complainant is more likely to have consented to sexual activity because she has engaged in sexual activity before, or that because she has engaged in prior sexual activity, that the court should consider her to be less credible or less worthy of belief.
And then under what circumstances will the evidence of a complainant's sexual history be admissible?
So the evidence can be admissible if the judge considers it to be relevant to an issue at trial, and if it has probative value, significant probative value, that is not substantially outweighed by its prejudice to the administration of justice. And so what that means specifically is that you need to articulate a reason why your lawyer needs to cross-examine the complainant about her prior sexual activity, and any prejudice that might flow from that, for example, to the complainant's dignity or her privacy interests, that needs to be outweighed by the probative value of that evidence.
And then when do these applications typically take place in the legal process?
They can be brought at any point during the process. If the matter is proceeding to trial, they can be brought mid-trial or before trial, but certainly the best practice is that any prior sexual activity that might be relevant is discussed early on in the process between the client and counsel, so that if this application needs to be brought, it should be brought pre-trial.
Well, thank you so much for all that information, Dan. And then thank you to everyone else for joining us today on the Legally Speaking Aitken Robertson YouTube channel. Don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website, or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.